Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. Jurisprudence class number 18. In this class, we are going to discuss the different types of obligations. The question may come as, why laws are obligatory? Explain with suitable illustrations. You may get a question like this. Why laws are obligatory? That means you all know that law creates rights, duties and obligations. Now we have to know what are the different types of obligation. First of all, the word obligation is derived from the verb obligare, O-B-L-I-G-A-R-E, obligare, means being bound by law. So since we are discussing the jurisprudence, being bound by law. So obligation. So please remember, according to John Salman, obligation may be defined as a proprietary right. Normally obligations will be in law, they are all proprietary right. So proprietary right, you know, right in personam or right in rem, right? Or please remember, the duty which is correlative to a right. So please remember, ultimately the term obligations means do an act or withdraw from doing an act. To do an act or not to do an act. Now with this definition or introduction, let us go to the different types of obligations. Only two major. They are sole obligation and solidary obligation. Not solitary, solidary obligation. What is sole obligation? So please remember, here there is only one creditor and one debtor. A is obliged to pay money to B. So one creditor and one debtor. So this is ekaika bhajyata. Whereas solidary obligation, that is sanghi bhava bhajyata, that means one creditor and more debtors. A has given to money to B, C, D. So all of them, they have got obligation to repay the money to A. Right? So here there is another point also. For example, if X and Y are the two partners and they have given a loan to Z about 1,000 rupees. X and Y, they have to claim for 1,000 rupees, not X 500 and Y 5,000. Yes, when you come to section 145 of the CPC or obligation of the surety, then you will be able to learn better. But anyway, here please note that solidary obligation means obligation to so many other persons also. Right? So already I told you John Salman, he defined obligation as a proprietary right, right in personam. This is important. You know right in rem and right in personam, but this is a right in personam or duty which corresponds to right. Just I have repeated that, so I did not tell anything new. Then what are the sources for obligation? What are the sources? Now we are going to discuss 4 sources. Number 1, contractual obligation. Section 2, clause H of the Indian Contract Act, it clearly says the obligation arising from the contracts. So please remember, if an obligation is created, it will become a right in personam. So that means a person has to pay certain amount. He has to full contractual obligation to the other person. So this is what is called contractual obligations. All of them are definitely proprietary rights. You know the contract. Contract means an agreement with the same mind of people. Then tortious obligation. This is also called as a delictual obligation, delinquency, tortious. So in the first semester itself, I told you what is a tort. Tort is a civil wrong which is not a breach of trust or breach of contract, and the remedial measure when injury is caused by means of unliquidated damages. This definition you must be thoroughly prepared. Right. So please remember, it is a civil wrong and the remedy is action for damages. The compensation will be in the shape of unliquidated. Any amount of compensation can be given. So you all know, you are thorough with the tort law, therefore I am not dealing with vicarious liability, that liability and this liability. Now third one is quasi contractual obligations. What is quasi contractual? That's also I told you in the law of torts. Quasi contractual means, quasi means as if. It's not a contract, but you have to think as if it is a contract. So this is quasi contractual contract. This is mainly intended to prevent the unjust enrichment. So please remember, I have told you the example of that boy ordering for a cell phone. Ultimately, father reprimanding him. They have cancelled, but the people sent it. So ultimately, the court said, no, you take the money, give him back the money, take back your cell phone. You should not get unjust enrichment with the innocent activity of a young boy. So this is quasi-contractual obligation. You know, finders and losers theory here has given X leaves his bag at a house of Y by mistake. X left his bag in the house of Y by mistake. Y has got a contractual obligation to return it back to X. This is what is meant. So there is a wonderful case in this contractual liability, unjust enrichment. In the case of West Bengal, State of West Bengal versus B.K. Mondal and Sons, 1961. It was held by the Supreme Court that if the state requested for certain works related to the construction, it could not reject the same, that there is no contract. So I will tell you what happened. So actually B.K. Mondal and Sons, they were actually taken contract for the construction of godowns. Godowns they have constructed. But the concerned engineer said, the godowns are okay, but there was no approach road, Baba. You go, you contract, you construct the road, we'll give money, we'll pay, we will sanction the money, like that he told. So believing him, they have laid the road also. Later, that man said, the work of laying the road is not the contract, therefore I am not going to pay. Is it correct? No, you should not get understood. So what happens is this engineer will sanction the amount in favor of some other contractor. That is what the reality. But whatever it is, please remember, when you have completed the work, when you have ordered the work, there is evidence. So you have to pay the money. You should not get it. So even though there is no contract, you have to think as if a contract was existence and you have to pay the money. So this is what is called contract. So quasi-contractual obligation. Then ఏది లేకపోతే, if it is not contractual, if it is not tortious, if it is not quasi-contractual, the other type is innonimate. This is what we call as saving clause. చాలా చోట్ల మనం saving clause లో కూడా చెప్తున్నాం, ఎక్కడా లేకపోతే. So please remember, innonimate means not named, not classified, all other things. Just like our Selman versus Winfield pigeonhole theory, whether it is a law of tort or whether it is a law of torts. So likewise, innonimate. So these obligations are in such a nature that normally we can't expect them. They may be coming in the way. Likewise, it has come in the Indian Trust Act 1882. So please remember, Section 81 of the Trust Act says, where there is a situation where the transferor wants to dispose of his beneficial interest, he has not clearly mentioned, then the innonimate obligations are created and the trustee has to fulfill the so-called innonimate obligations. అతను డోనర్ ఎవరైతే ఉన్నాడో ఆ డోనర్ గారు తన యొక్క పొలాన్ని, దీంట్లో ఉన్నదాన్ని 2 ఎకరాలు వాళ్ళకి 2 ఎకరాలు వీళ్ళకి ఏదో క్లియర్గా చెప్పనప్పుడు ఇది ఆబ్లిగేషన్ ఇస్ దేర్. ఆయన చనిపోయిన తర్వాత అవన్నీ ఉంది, కానీ ఎవరికి ఎంతో చెప్పాలి. అలాంటప్పుడు ద ట్రస్టీ హ్యాస్ గోట్ ద లయబిలిటీ టు ఫుల్ఫిల్ ద సో కాల్డ్ innonimate obligations. So please remember, where a person is liable to pay to another person is called solidary obligation. This is what's called sole obligation. And if there is one creditor and 2 or more debtors, it is called solidary obligation. So please remember, rights cannot exist without liabilities. So obligation is also liability. So normally it can be called as an obligation or as a right also, because it is from the legal point of view, definitely you have got a right to collect and you have got a right to pay also. So please remember, the obligations come, they are in the everyday life also. Please remember, if there is no obligation, then chaos will come to the society. So that's all regarding the obligations. Friends, in this class we have discussed sole obligation, solidary obligation, contractual obligation, quasi-contractual obligation. tortious obligation and innonimate obligation. So please study the material. Definitely you will understand better. Thank you.